The U.S. Supreme Court wrapped up arguments for this term with two of the most hot-button issues of the year: abortion and former President Trump's claim of immunity from prosecution. Based on those oral arguments in both cases, the justices seem divided on both issues. In the Idaho abortion case, the justices grappled with whether provisions of Idaho's near-total abortion ban unlawfully conflict with a federal law aimed at ensuring certain standards for emergency medical care for patients. And in the case of the former president, it appears some of the justices appear open to giving Trump some level of protection as they weigh whether presidents are fully immune from prosecution over anything they did in office or even after it. Jonathan Adler joins us now. He is a constitutional law professor at Case Western Reserve University. Thanks so much for being with us. So the Supreme Court really appeared divided as it wrestled with a case pitting Idaho's near-total ban on abortion against a federal law that requires hospitals provide stabilizing care to patients experiencing medical emergencies. When the Supreme Court does indeed rule, what do you expect their ruling to be on this based on what you heard?
Well, what we heard is that the justices were struggling with the extent to which this law called EMTALA, the Emergency Medical Treatment in Labor Act, conflicts with an Idaho law that effectively prohibits abortion except where necessary to save the life of the mother. And key in this dispute is whether or not there are situations in which, under EMTALA, a woman who's pregnant, who's in the emergency room, would need an abortion to stabilize her and to protect her life, and whether or not that would be allowed under Idaho law. The justices both seem divided on the extent to which we should read EMTALA as a preemptive law, but also how much of a conflict there actually is in terms of specific cases in which federal law would say the abortion should be provided and state law would not. I think a majority of the justices are skeptical that there is a conflict, or at least a conflict in this facial posture. That is the posture just looking at the two statutes as opposed to considering a specific situation or involving a specific patient. So I suspect the Idaho law will be upheld, but probably narrowly, with language making clear that on the face of it, it's not clear that there is the degree of conflict that the federal government suggests.
It was certainly interesting to listen to those arguments. And this case could ultimately affect other states' abortion ban exceptions for the life or health of the mother. We talk about the national legal implications for emergency access to abortion and what's really at stake here for women across America because of this.
Well, it has a big effect on hospitals that accept Medicaid patients, which is certainly most hospitals throughout the country. And generally, federal law requires that all those hospitals meet certain standards in emergency room care. The idea is to prevent the old practice of hospitals essentially shuttling away or transferring patients that they don't want to care for, perhaps because of ability to pay. And the resolution of this law will clarify the extent to which those requirements preempt or limit the ability of states to restrict the termination of pregnancies or performing abortions in the context of emergency room care.
Bottom line, do you think this puts American women's lives at risk?
Idaho says no. So that's one of the things the justices were struggling with. Idaho claims that, as interpreted by the Idaho Supreme Court, their law requires an exception for the life and health of the mother, that any emergency procedure that is necessary to stabilize the woman would still be allowed. And we'll get some clarification on that point, too, from this ruling.
And let's turn to the other really big Supreme Court oral arguments we heard this week involving former President Donald Trump. On Thursday, the justices heard arguments on Trump's claim of immunity from prosecution for alleged criminal acts during his official capacity as president. There were debate between personal presidential acts. Based on the questions the justices asked and what you heard, any indications of where the justices are leaning here?
Well, I don't think there are 5 votes to uphold Donald Trump's claims of very broad immunity. The question is whether or not there are 5 votes to settle on a clear line that divides those activities that are immune from federal prosecution, such as the president's core exclusive executive authority, and those things that are on the margin. The federal government acknowledged that there are things that a president can do that Congress cannot limit, that Congress cannot criminalize. And it's very clear that a majority of the justices aren't going to accept the idea that any time a president claims to be acting officially that they're necessarily immune. So the example that kept coming up is the president ordering the military to assassinate a rival. No one seemed to indicate that that would be a basis for immunity. The question is, where do you draw the line when the president is, say, calling up somebody who they might want to appoint as acting attorney general and making recommendations about how to handle an election conflict that seems to implicate the president as a candidate more than the president as president? I suspect the court is going to give us a test that will allow most of Jack Smith's charges to go forward. The problem for the prosecution is that this will probably require additional proceedings in the trial court as the court kind of works through which of the allegations involve conduct that can be prosecuted and which, if any, allegations involve conduct that has to be immune.
Now, all of this sounding like it's going to take certainly a lot of time. Do you think that the court possibly buying Trump more time here, likely what he wants, is a big win for him? And do you think there's any chance we see resolution on this before the election?
I think there's a chance, but certainly, it will take a month or two probably for the Supreme Court to issue a decision. And then depending what their decision looks like, that may require the trial court to have some additional proceedings specifically on the question of where these where these different allegations lie. The federal government's position is that should be able to be done on what we call an as-applied basis during the trial. That is to say, at any point in which the defense thinks that a claim involves protected conduct, let that issue be raised at that point, but let the trial proceed. If that were to happen, we could presumably have a trial that would end late summer, early fall. But I don't think the Supreme Court is trying to rush this. I don't think that's because they're concerned about Donald Trump. I think rather it's because they're concerned about drawing a line that will work going forward. Because whatever line they draw here is going to apply to all presidents in the years to come. And it was very clear that many of the justices were very concerned about how to define that line, what to write in their opinion that instructs lower courts and prosecutors where the line is between protected and unprotected conduct.
That's something we heard them say time and time again. This will impact all future presidents. So really a lot on the line here. Jonathan Adler, constitutional law professor at Case Western Reserve University. Thank you.
Thank you.